Question 1. Which approach would be most appropriate for an official in Estonia when processing an application for a weapon permit, Relvaluba, under the Estonian Weapons Act? Option A. Expedite the weapon permit application by overlooking minor inconsistencies in the submitted documents, assuming the applicant is trustworthy. Option B. Deny the weapon permit based on informal reports or personal suspicions about the applicant's character, without a formal investigation or documented legal grounds. Option C. Issue the weapon permit based on the applicant's expressed intent and a brief personal interview, without requiring detailed medical or psychological evaluations. Option D. Conduct a thorough review of all submitted documentation, including medical certificates and psychological assessments, to ensure compliance with the requirements of the Estonian Weapons Act. Correct answer is D. Conduct a thorough review of all submitted documentation, including medical certificates and psychological assessments, to ensure compliance with the requirements of the Estonian Weapons Act. Explanation. Scenario analysis. This scenario presents a professional challenge due to the sensitive nature of firearm ownership and the potential for misuse. A thorough and legally compliant assessment of an applicant's suitability for a weapon permit is paramount to public safety and adherence to Estonian law. The challenge lies in balancing the applicant's rights with the state's responsibility to regulate firearms effectively. Correct approach analysis. The best approach involves a comprehensive review of all submitted documentation, including the medical certificate, psychological assessment, and any other required forms as stipulated by the Estonian Weapons Act, Relvaluba. This approach is correct because it directly aligns with the legal requirements for obtaining a weapon permit in Estonia. The law mandates specific documentation to ensure the applicant is not a risk to themselves or others. A thorough review ensures that all statutory criteria are met before a permit is issued, upholding the principle of responsible firearm ownership. Incorrect approach is analysis. One incorrect approach would be to issue the permit solely based on the applicant's stated intent and a brief interview, without verifying the submitted medical and psychological evaluations. This fails to comply with the Estonian Weapons Act, which requires objective evidence of the applicant's fitness to possess a weapon. Such an approach creates a significant public safety risk by bypassing crucial assessment stages. Another incorrect approach would be to deny the permit based on unsubstantiated rumors or personal biases, without a formal, documented investigation or a clear violation of the legal criteria. This violates principles of fairness and due process, as well as the specific provisions of the Weapons Act that outline grounds for refusal. Decisions must be based on evidence and established legal grounds. A further incorrect approach would be to expedite the process by overlooking minor discrepancies in the documentation, assuming good faith. While efficiency is desirable, the Weapons Act requires strict adherence to documentation standards. Overlooking discrepancy, even minor ones, could inadvertently permit an unsuitable individual to obtain a weapon, thereby compromising public safety and violating the spirit and letter of the law. Professional reasoning. Professionals in this field must adopt a systematic and evidence-based decision-making process. This involves meticulously reviewing all statutory requirements, thoroughly examining all submitted documentation against these requirements, and conducting any necessary further investigations in a fair and impartial manner. When faced with ambiguity or potential concerns, professionals should err on the side of caution and seek clarification or additional information, always prioritizing public safety and legal compliance as mandated by the Estonian Weapons Act. Question 2. Investigation of an application for a weapon permit, Relvaluba, in Estonia, reveals that the applicant has a history of 2 minor convictions for public order disturbances, occurring 5 and 7 years prior to the application. The applicant has no other criminal record and has provided references attesting to their good character. What is the most appropriate course of action for the permit-issuing authority? Option A. Grant the weapon permit application based on the applicant's current good character and the absence of recent offenses, without further investigation into the specifics of the past convictions. Option B. Deny the weapon permit application outright due to the presence of any criminal convictions, regardless of their nature or age. Option C. Immediately approve the weapon permit application, as the offenses are minor and occurred a significant time ago, and the applicant has provided positive references. Option D. Conduct a detailed review of the specific nature of the public order disturbances and the applicant's subsequent conduct, assessing them against the disqualifying criteria outlined in the Estonian Weapons Act, and consult relevant authorities if necessary before making a decision. The correct answer is D. Conduct a detailed review of the specific nature of the public order disturbances and the applicant's subsequent conduct, assessing them against the disqualifying criteria outlined in the Estonian Weapons Act, and consult relevant authorities if necessary before making a decision. Explanation. This scenario presents a professional challenge due to the sensitive nature of firearm ownership and the potential for public safety risks. The applicant's history of minor offenses requires careful consideration against the strict requirements for obtaining a weapon permit, Relvaluba, in Estonia. The decision-maker must balance the applicant's right to potentially own a firearm with the paramount duty to protect public safety, adhering strictly to the Estonian Weapons Act, Relvaluba, and associated regulations. The correct approach involves a thorough and objective assessment of the applicant's entire criminal record, specifically evaluating whether any past offenses, even minor ones, fall under the disqualifying criteria outlined in the Estonian Weapons Act. This includes scrutinizing the nature of the offenses, the time elapsed since their commission, and any mitigating or aggravating circumstances. The Estonian Weapons Act, specifically Article 17, lists grounds for refusal, including convictions for certain offenses, or if the applicant poses a threat to public order or safety. A comprehensive review, potentially including consultation with law enforcement or mental health professionals if deemed necessary by the permit-issuing authority, is crucial to ensure compliance with the spirit and letter of the law. This approach prioritizes public safety by rigorously applying the legal framework to determine eligibility. An incorrect approach would be to dismiss the applicant's past offenses solely because they are considered minor or occurred a significant time ago without a detailed legal analysis. The Estonian Weapons Act does not automatically exempt individuals based on the perceived severity or age of past offenses. Rather, it requires an assessment of whether these offenses demonstrate a propensity for violence or a disregard for the law that would make them an unsuitable candidate for firearm ownership. Another incorrect approach would be to grant the permit based on a personal belief that the applicant has reformed, without a formal, documented assessment against the legal criteria. Such a subjective decision bypasses the regulatory framework and undermines the objective standards set for public safety. Finally, failing to consult relevant legal provisions or internal guidelines when evaluating the application would be a significant regulatory failure, as it demonstrates a lack of diligence and adherence to established procedures. Professionals should employ a structured decision-making process that begins with a complete understanding of the relevant legal framework, Estonian Weapons Act. This involves meticulously gathering all necessary documentation, including the applicant's criminal record. Each piece of information must then be systematically evaluated against the statutory disqualifying criteria. If any ambiguity exists, or if the information suggests a potential risk, further investigation or consultation with relevant authorities or experts should be initiated. The final decision must be documented, clearly articulating the rationale based on the legal assessment and the evidence reviewed, ensuring transparency and accountability. Question 3. Assessment of an application for a Relvaluba weapon permit in Estonia is being conducted for an individual who has provided a medical certificate indicating a past diagnosis of anxiety disorder, which has since been reported as managed. The applicant also has a record of minor disciplinary infractions from their youth, unrelated to violence or weapon use. What is the most appropriate course of action for the issuing authority? Option A. Issue a provisional Relvaluba, allowing the applicant to possess a weapon under strict supervision for a trial period, without a formal assessment of their current mental and physical capacity as per legal requirements. Option B. Deny the Relvaluba application immediately due to the applicant's history of anxiety disorder and past disciplinary issues, as these factors inherently suggest a lack of suitability for weapon ownership. Option C. Grant the Relvaluba application without further inquiry, assuming that the applicant's self-reported management of anxiety and the nature of past disciplinary issues are sufficient indicators of current suitability. Option D. Conduct a thorough review of all submitted documentation, including the medical certificate and details of past disciplinary actions, and if any concerns remain regarding current suitability or capacity, request further clarification or additional medical assessments from the applicant or relevant professionals, in accordance with the Estonian Weapons Act. The correct answer is D. Conduct a thorough review of all submitted documentation, including the medical certificate and details of past disciplinary actions, and if any concerns remain regarding current suitability or capacity, request further clarification or additional medical assessments from the applicant or relevant professionals, in accordance with the Estonian Weapons Act. Explanation: this scenario is professionally challenging because it requires balancing an individual's right to apply for a weapon permit with the stringent safety and suitability requirements mandated by Estonian law. The applicant's history presents a potential risk, necessitating a thorough and objective assessment that adheres strictly to the Relvaluba weapon permit regulations. The core of the challenge lies in interpreting the applicant's past behavior and medical information in the context of the legal criteria for weapon ownership, ensuring public safety without unfairly penalizing the individual. The best approach involves a comprehensive review of all submitted documentation, including medical certificates and any relevant police records, to determine if the applicant meets the criteria outlined in the Estonian Weapons Act, Relvaluba, and associated regulations. This includes assessing the applicant's mental and physical capacity to handle a weapon safely, as well as their general suitability, which considers past conduct. If any doubts arise regarding the applicant's suitability or capacity, the responsible authority must request further information or clarification from the applicant or relevant medical professionals, following the procedures stipulated by law. This ensures a decision is made based on complete and accurate information, upholding the principle of public safety while respecting due process. An incorrect approach would be to deny the permit solely based on the applicant's past disciplinary issues, without a thorough assessment of their current mental and physical state, or without considering the nature and recency of the disciplinary actions in relation to weapon handling. This fails to adhere to the legal requirement of assessing current suitability and capacity. Another incorrect approach would be to grant the permit without seeking clarification on potentially concerning medical information, thereby potentially compromising public safety and violating the duty of care mandated by the Weapons Act. Finally, an approach that relies on informal consultations or personal opinions rather than documented evidence and legal criteria would be professionally unacceptable, as it bypasses the established regulatory framework for weapon permit applications in Estonia. Professionals in this field should employ a structured decision-making process. This begins with a meticulous review of all submitted documents against the explicit requirements of the Estonian Weapons Act. If the initial review reveals any ambiguities or potential concerns, the next step is to proactively seek further information through legally prescribed channels, such as requesting additional medical reports or clarification from the applicant. Decisions must be grounded in objective evidence and legal provisions, ensuring fairness to the applicant and paramount consideration for public safety. Question 4. The audit findings indicate that a firearm permit holder in Estonia, Mr. Janis, has been storing his legally acquired handgun unloaded in a bedside drawer for quick access in case of a perceived threat, while keeping the ammunition in a separate unlocked box on his nightstand. Based on the Estonian Weapons Act, Relvaluba, which of the following storage practices best aligns with regulatory requirements and public safety principles? Option A. Storing the firearm loaded but in a locked safe. Option B. Keeping the firearm unloaded in a bedside drawer for immediate access, with ammunition in an unlocked box on the nightstand. Option C. Storing the firearm unloaded in a locked safe that meets the specifications outlined by the Estonian Police and Border Guard Board, with ammunition stored separately and securely. Option D. Storing the firearm unloaded in a locked cabinet, but keeping the ammunition readily accessible in the same room. Correct answer is C. Storing the firearm unloaded in a locked safe that meets the specifications outlined by the Estonian Police and Border Guard Board, with ammunition stored separately and securely. Explanation: the audit findings indicate a potential lapse in adherence to the Estonian Weapons Act, Relvaluba, concerning the storage of firearms. This scenario is professionally challenging because it requires the responsible person to balance the immediate need for access to a weapon for self-defense against the stringent legal requirements for secure storage, designed to prevent unauthorized access and potential misuse. Misinterpreting or neglecting these requirements can lead to severe legal consequences, including the revocation of the weapon permit and criminal charges. The correct approach involves ensuring that the firearm is stored in a locked safe or a designated secure location that meets the requirements stipulated by the Estonian Police and Border Guard Board, as outlined in the Weapons Act and its implementing regulations. This means the weapon should not be readily accessible, even for the permit holder, unless it is being transported or used in accordance with the law. The primary regulatory justification is the prevention of accidents, theft, and unauthorized use, which is a core tenet of firearm control legislation in Estonia. The law prioritizes public safety by mandating secure storage. An incorrect approach would be to keep the firearm unloaded but in a bedside drawer. This fails to meet the legal definition of secure storage under the Estonian Weapons Act, as it does not prevent unauthorized access by individuals other than the permit holder, such as children or visitors. The regulatory failure lies in not providing a physical barrier or locking mechanism that would deter or prevent access. Another incorrect approach would be to store the firearm unloaded in a locked cabinet, but to leave the ammunition readily accessible in the same room. While the firearm itself is secured, the proximity of ammunition significantly reduces the time and effort required for an unauthorized person to assemble and use the weapon, thereby undermining the spirit and intent of the secure storage regulations. The ethical failure here is a disregard for the comprehensive safety measures intended by the law. A further incorrect approach would be to store the firearm loaded but in a locked safe. This is a critical violation of the Estonian Weapons Act, which explicitly prohibits the storage of firearms in a loaded state, except under very specific and limited circumstances not applicable to general home storage. The regulatory failure is a direct contravention of a fundamental safety provision designed to prevent accidental discharge. Professionals should adopt a decision-making framework that prioritizes a thorough understanding of the specific requirements of the Estonian Weapons Act and its associated regulations. This involves consulting official guidelines from the Estonian Police and Border Guard Board, and if in doubt, seeking clarification directly from the issuing authority. The process should involve a risk assessment of the storage method, ensuring it meets or exceeds the legal minimums for security and accessibility control. Question 5. Risk assessment procedures indicate that an individual in Estonia has expressed an urgent need for a firearm for personal protection due to recent threats. The individual approaches the local police and border guard board office and verbally states their situation, requesting immediate authorization to purchase a weapon. What is the legally mandated and professionally appropriate course of action for the firearms officer? Option A. Accept the applicant's verbal confirmation of having a clean criminal record and a general statement of good health as sufficient grounds to proceed with the permit application. Option B. Issue a temporary permit based on the applicant's verbal assurance of needing the weapon for self-defense, pending the submission of formal documentation at a later date. Option C. Expedite the permit process by immediately authorizing the purchase, with the understanding that the applicant will submit the necessary medical and criminal record certificates within the following week. Option D. Advise the individual that a formal written application, along with all required supporting documentation including proof of identity, a medical certificate confirming fitness to handle a weapon, and a certificate of no criminal record, must be submitted and processed according to the procedures outlined in the Estonian Weapons Act before any permit can be considered. The correct answer is D. Advise the individual that a formal written application, along with all required supporting documentation including proof of identity, a medical certificate confirming fitness to handle a weapon, and a certificate of no criminal record, must be submitted and processed according to the procedures outlined in the Estonian Weapons Act before any permit can be considered. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the firearms officer to balance the immediate need for information with the strict legal requirements for obtaining a weapon permit in Estonia. Misinterpreting or circumventing these requirements can lead to serious legal consequences for both the applicant and the issuing authority, undermining public trust and safety. The officer must exercise careful judgment to ensure all procedural steps are followed meticulously. Correct approach analysis. The best professional practice involves adhering strictly to the procedures outlined in the Estonian Weapons Act, Relvaluba, and associated regulations. This means that the applicant must first submit a complete application form, including all required supporting documents, to the Police and Border Guard Board. Only after the Police and Border Guard Board has reviewed the application conducted necessary background checks, and determined that the applicant meets all legal criteria, can a permit be issued. This approach is correct because it directly aligns with the legal framework established to ensure that only eligible individuals are granted weapon permits, thereby upholding public safety and the rule of law. The process is designed to be thorough and prevent unauthorized access to firearms. Incorrect approaches analysis. One incorrect approach involves issuing a temporary permit based solely on the applicant's stated intention to acquire a weapon for self-defense, without completing the formal application and background check process. This fails to comply with the Estonian Weapons Act, which mandates a comprehensive review before any permit is granted, bypasses essential safety checks, and could lead to a weapon being in the hands of an individual who has not met the legal requirements. Another incorrect approach is to accept a verbal confirmation of the applicant's clean criminal record as sufficient evidence. The Estonian Weapons Act requires documented proof, typically through official certificates, to verify an applicant's eligibility. Relying on verbal assurances is insufficient and opens the door to potential misrepresentation or incomplete information, compromising the integrity of the permit issuance process. A further incorrect approach is to expedite the permit process by overlooking the requirement for a medical examination certificate. The law explicitly requires proof of physical and mental fitness to handle a weapon. Skipping this crucial step, even with good intentions, violates the legal mandate and poses a significant risk to public safety. Professional reasoning. Professionals in this field must adopt a systematic and legally compliant decision-making process. This involves 1. Thoroughly understanding the relevant legislation, Estonian Weapons Act and its implementing regulations. 2. Ensuring all required documentation is submitted by the applicant. 3. Conducting all mandated checks, background, medical, etc., without deviation. 4. Issuing permits only when all legal prerequisites are demonstrably met. 5. Maintaining accurate and complete records of all applications and decisions. This structured approach ensures both legal compliance and the effective execution of public safety duties. Question 6. The audit findings indicate that a licensed firearm permit holder in Estonia, residing in Tallinn, has been storing their handgun in a locked wooden chest in their bedroom when not actively carrying it. The permit holder states they are always home when the firearm is stored this way and believe this constitutes adequate security. Based on the Estonian Weapons Act, Relvaluba, what is the most appropriate course of action for the permit holder to ensure compliance? Option A. Store the handgun in a locked gun case but keep the ammunition in the same room, easily accessible. Option B. Store the handgun on a high shelf in a locked closet, ensuring it is out of reach of children. Option C. Secure the handgun in a certified gun safe or a securely locked storage box, with ammunition stored separately and also securely locked, regardless of whether the permit holder is present in the home. Option D. Continue storing the handgun in the locked wooden chest, as the permit holder is always present in the home, which they believe is sufficient security. The correct answer is C. Secure the handgun in a certified gun safe or a securely locked storage box, with ammunition stored separately and also securely locked, regardless of whether the permit holder is present in the home. Explanation. The audit findings indicate a potential lapse in adherence to the Estonian Weapons Act, Relvaluba, concerning the storage of firearms. This scenario is professionally challenging because it requires the responsible person to balance the immediate need for access to a weapon for self-defense with the stringent legal requirements for secure storage, designed to prevent unauthorized access and potential misuse. Misinterpreting or neglecting these requirements can lead to severe legal consequences, including permit revocation and criminal charges, and more importantly, compromise public safety. The correct approach involves understanding that the Estonian Weapons Act mandates that firearms must be stored in a manner that prevents unauthorized access, even when the permit holder is present in the immediate vicinity. This typically means using a certified gun safe or a secure storage box that is locked, with ammunition stored separately and also securely. This approach is correct because it directly aligns with the primary objective of the Relvaluba, which is to ensure public safety by minimizing the risk of firearms falling into the wrong hands. The law prioritizes secure storage over immediate accessibility for self-defense when the permit holder is not actively carrying the weapon. An incorrect approach would be to leave the firearm in a locked drawer within the home, even if the permit holder is present. This fails to meet the legal standard of preventing unauthorized access, as a locked drawer is generally not considered a sufficiently secure storage solution under the Relvaluba, especially if it can be easily opened by someone other than the permit holder. Another incorrect approach is to store the firearm on a high shelf in a closet without a locking mechanism. This is a clear violation of the Act's security requirements, as it offers no protection against unauthorized access by children, visitors, or intruders. Finally, storing the firearm in a locked gun case but leaving the ammunition readily accessible in the same room is also an unacceptable approach. While the firearm itself might be secured, the proximity of unsecured ammunition significantly increases the risk of immediate misuse if the firearm were to be accessed by an unauthorized individual. Professionals facing such situations should adopt a decision-making framework that prioritizes a thorough understanding of the specific legal requirements of the Relvaluba. This involves consulting the official text of the law and any relevant guidelines issued by the Estonian Police and Border Guard Board. When in doubt, seeking clarification from the authorities is paramount. The decision should always err on the side of caution, ensuring that the chosen storage method unequivocally meets or exceeds the legal standards for preventing unauthorized access, even if it introduces a minor inconvenience for the permit holder. Question 7. The audit findings indicate that an applicant for a Relvaluba weapon permit in Estonia has submitted a medical certificate stating they were treated for anxiety several years ago, but the certificate does not provide details on their current mental state or any specific assessment of their fitness to handle firearms. What is the most appropriate course of action for the firearms licensing authority? Option A. Rely on the submitted medical certificate, assuming that past treatment for anxiety does not preclude current fitness to possess a firearm, and proceed with the application. Option B. Deny the Relvaluba application based on the applicant's history of mental health treatment as a precautionary measure to ensure public safety. Option C. Immediately approve the Relvaluba application, as the applicant has not been formally diagnosed with a disqualifying mental illness and has provided a medical certificate. Option D. Request a comprehensive, up-to-date medical certificate from the applicant's treating physician that specifically addresses their current mental state and suitability to possess a firearm, in accordance with the Estonian Weapons Act. The correct answer is D. Request a comprehensive, up-to-date medical certificate from the applicant's treating physician that specifically addresses their current mental state and suitability to possess a firearm, in accordance with the Estonian Weapons Act. Explanation. Scenario analysis. This scenario presents a professional challenge for an Estonian firearms licensing authority when processing a Relvaluba weapon permit application. The challenge lies in balancing the applicant's stated need for a firearm with the statutory requirements for assessing their suitability and the potential risks associated with their mental health history, particularly when the information provided is incomplete or potentially misleading. The authority must exercise careful judgment to ensure public safety without unfairly penalizing an individual who may be fit to own a weapon. Correct approach analysis. The best professional practice involves a thorough and systematic review of the application, cross-referencing the provided medical information with the requirements of the Estonian Weapons Act, Relvaluba. This approach necessitates requesting a comprehensive medical certificate from the applicant's treating physician, specifically addressing their current mental state and any history of conditions that could impair their judgment or control, as stipulated by the Relvaluba. This ensures that the decision is based on up-to-date and relevant medical evidence, directly addressing the statutory criteria for permit issuance. Incorrect approaches analysis. One incorrect approach involves immediately approving the permit based solely on the applicant's self-declaration and the absence of a formal diagnosis of a disqualifying mental illness. This fails to meet the due diligence required by the Relvaluba, which mandates an assessment of the applicant's mental fitness. It overlooks the potential for latent conditions or the impact of past treatment on current suitability, thereby compromising public safety. Another incorrect approach is to deny the permit outright based on the mention of past treatment for anxiety without further investigation. The Relvaluba does not automatically disqualify individuals with a history of mental health treatment. A blanket denial without obtaining current medical assessments or considering the nature and resolution of the past condition is discriminatory and contrary to the principle of individualized assessment mandated by the law. A third incorrect approach is to rely on outdated medical information from several years prior without seeking an updated assessment. The Relvaluba emphasizes current fitness. Past conditions, even if treated, may evolve, and an assessment from years ago may not accurately reflect the applicant's present mental state and capacity to safely handle a firearm. Professional reasoning. Professionals in firearms licensing must adopt a risk-based, evidence-driven approach. This involves understanding the specific legal requirements of the Relvaluba, particularly concerning medical fitness. When faced with incomplete or potentially concerning information, the professional decision-making process should prioritize obtaining all necessary, current, and relevant evidence to make an informed decision. This includes proactively seeking clarification and further documentation from applicants and their medical providers, rather than making assumptions or relying on incomplete data. The goal is to uphold public safety while ensuring fair and lawful processing of applications. Question 8. The risk matrix shows a moderate likelihood of a firearm being misused due to a lapse in secure storage, coupled with a high impact if such misuse occurs. Mr. John, an applicant for a Relvaluba in Estonia, has no criminal record but has been involved in several documented, non-criminal disputes with neighbors over property boundaries. The issuing authority is considering the application. Which of the following represents the most responsible and legally compliant course of action? Option A. Conduct a thorough, individualized assessment including a personal interview with Mr. John to discuss his understanding of firearm safety, his conflict resolution strategies, and his commitment to secure storage, alongside a discreet inquiry into the nature of the disputes. Option B. Forward the application and all associated documentation to the Estonian police for an immediate decision, as they are best equipped to assess public safety risks. Option C. Deny the Relvaluba outright due to the documented disputes, as this indicates a potential lack of temperament for responsible firearm ownership. Option D. Grant the Relvaluba immediately, as Mr. John has no criminal convictions, which is the primary legal disqualifier. The correct answer is A. Conduct a thorough, individualized assessment including a personal interview with Mr. John to discuss his understanding of firearm safety, his conflict resolution strategies, and his commitment to secure storage, alongside a discreet inquiry into the nature of the disputes. Explanation. The risk matrix shows a moderate likelihood of a firearm being misused due to a lapse in secure storage, coupled with a high impact if such misuse occurs. This scenario is professionally challenging because it requires balancing an individual's right to own a firearm with the paramount public safety imperative. The applicant, Mr. John, has a history of minor disputes, which, while not criminal convictions, raise concerns about his judgment and temperament when under stress. The Estonian Weapons Act, Relvaluba, and associated regulations place a significant onus on the issuing authority to ensure that firearm permits are granted only to individuals who are demonstrably responsible and pose no undue risk. The core of the challenge lies in assessing the subjective risk posed by an individual based on objective, albeit non-criminal, indicators. The best professional approach involves a thorough, individualized assessment that goes beyond a simple check of criminal records. This includes a detailed review of Mr. John's personal circumstances, his stated reasons for seeking the permit, and any available information regarding his past behavior that might indicate a propensity for impulsive or irresponsible actions. Specifically, this approach would involve conducting a personal interview with Mr. John to gauge his understanding of firearm safety, his emotional state, and his commitment to secure storage. Would also involve discreet inquiries into the nature of the reported disputes to ascertain if they reveal a pattern of aggression or poor conflict resolution. This comprehensive evaluation is mandated by the Relvaluba, which requires the permit authority to be satisfied that the applicant is a responsible person and that granting the permit would not endanger public safety. The emphasis is on proactive risk mitigation through diligent investigation. An incorrect approach would be to grant the permit solely based on the absence of criminal convictions. This fails to acknowledge the broader responsibilities outlined in the Relvaluba, which permit authorities to consider factors beyond formal legal sanctions. The law implicitly requires a proactive assessment of character and suitability, not merely a passive check for disqualifying offenses. Another incorrect approach would be to deny the permit summarily based on the reported disputes without further investigation. While the disputes are a red flag, the Relvaluba requires a reasoned decision. A denial must be based on a demonstrable risk to public safety, which necessitates understanding the context and severity of these disputes, rather than assuming they automatically disqualify the applicant. Finally, an incorrect approach would be to defer the decision entirely to the police without conducting an independent assessment. While police input is valuable, the ultimate responsibility for issuing the permit rests with the designated authority, who must exercise their own judgment based on all available information. The professional reasoning process should involve a structured risk assessment framework. This begins with identifying potential risks, e.g., misuse due to poor judgment, inadequate storage. Next, gather all relevant information, including the applicant's history, stated purpose, and any reported incidents. Evaluate this information against the criteria set out in the Relv, focusing on whether the applicant is a responsible person and if granting the permit would endanger public safety. Document all findings and the rationale for the decision. If there are significant concerns, further investigation or an interview is warranted. The decision must be objective, evidence-based, and clearly articulated. Question 9. Process analysis reveals that a firearms officer in Estonia is reviewing an application for a Relvaluba weapon permit. The applicant has provided all standard documentation, but the officer recalls a minor public disturbance incident from several years ago involving the applicant, which did not result in a conviction. The officer also notes that the applicant's employer has provided a positive reference. The officer is considering how to proceed with the assessment. Which of the following approaches best aligns with the requirements of the Estonian Weapons Act, Relvaluba, and professional ethical standards for assessing an applicant's suitability for a weapon permit? Option A. Immediately refuse the permit based on the memory of the past public disturbance incident, as any such incident, regardless of its outcome, indicates a lack of good repute. Option B. Grant the permit without further investigation, assuming the positive employer reference and lack of conviction negate any potential concerns from the past incident. Option C. Deny the permit based on the unsubstantiated rumor of the public disturbance incident, without attempting to verify its accuracy or relevance. Option D. Conduct a thorough review of all submitted documents, cross-reference information with relevant databases, and if the minor incident is deemed significant after further investigation, document the findings and justification for any potential refusal or conditions based on the applicant's overall trustworthiness and good repute as defined by the Weapons Act. The correct answer is D. Conduct a thorough review of all submitted documents, cross-reference information with relevant databases, and if the minor incident is deemed significant after further investigation, document the findings and justification for any potential refusal or conditions based on the applicant's overall trustworthiness and good repute as defined by the Weapons Act. Explanation. Scenario analysis. This scenario presents a professional challenge due to the sensitive nature of firearm ownership and the potential for misuse. A firearms officer must balance the applicant's right to apply for a permit with the paramount public safety interest. The officer's judgment requires a thorough understanding of the Estonian Weapons Act, Relvaluba, and its implementing regulations, specifically concerning the assessment of an applicant's suitability and the grounds for refusal. The challenge lies in interpreting subjective criteria like trustworthiness and good repute in a consistent and legally defensible manner, while also considering the applicant's personal circumstances and potential risks. Correct approach analysis. The best professional practice involves a meticulous and objective review of all submitted documentation, cross-referencing information with available databases, and where necessary, conducting further inquiries as permitted by law. This approach prioritizes adherence to the Estonian Weapons Act, which mandates that the police assess whether an applicant poses a risk to public order or safety. Specifically, Section 29 of the Weapons Act outlines grounds for refusal, including a lack of trustworthiness or good repute, or if the applicant has a history of violence or substance abuse. A thorough investigation ensures that the decision is based on concrete evidence and legal requirements, rather than assumptions or personal biases. This aligns with the ethical obligation to protect public safety while respecting individual rights. Incorrect approaches analysis. One incorrect approach involves making a decision based solely on a single, potentially minor, past infraction without considering the applicant's overall history or current circumstances. This fails to comply with the holistic assessment required by the Weapons Act, which looks at the applicant's overall trustworthiness and good repute. It risks an arbitrary refusal, which could be challenged legally. Another incorrect approach is to grant the permit without conducting any independent verification of the information provided by the applicant, relying entirely on self-declarations. This neglects the police's duty to ensure the accuracy of information relevant to public safety and could lead to a permit being issued to an unsuitable individual, violating the spirit and letter of the Weapons Act. A further incorrect approach is to deny the permit based on unsubstantiated rumors or hearsay from third parties without any corroborating evidence. The Weapons Act requires decisions to be based on factual grounds and evidence, not on speculation or unverified information, which would be procedurally unfair and legally unsound. Professional reasoning. Professionals in this role should adopt a systematic decision-making process. This begins with a comprehensive understanding of the relevant legislation, particularly the Estonian Weapons Act and its associated regulations. When evaluating an application, the officer must gather all required documentation, conduct thorough background checks, and verify information where necessary. Any potential concerns should be investigated further, adhering strictly to legal procedures and respecting the applicant's rights. Decisions must be documented meticulously, with clear justifications grounded in the law and the evidence gathered. In cases of doubt or complexity, seeking guidance from senior officers or legal counsel is advisable. This structured approach ensures fairness, legality, and the effective protection of public safety. Question 10. Governance review demonstrates that a resident of Estonia, Mr. John Kallas, is applying to renew his Relvaluba for a hunting rifle. His current permit is valid for 5 years. Based on the Estonian Weapons Act and associated regulations, what is the correct renewal fee Mr. Kallas must pay? Option A, Euros 40. Option B, Euros 20. Option C, Euros 30. Option D, Euros 10. The correct answer is B, Euros 20. Explanation. Scenario analysis. This scenario presents a professional challenge in accurately calculating the required fees for a weapon permit renewal in Estonia, specifically concerning the firearm type and its associated duration. Miscalculation can lead to underpayment, potentially delaying the permit renewal process and incurring penalties or overpayment, which is inefficient. Adherence to the specific fee structure outlined in Estonian legislation is paramount for lawful and efficient permit management. Correct approach analysis. The best professional practice involves a precise calculation based on the firearm's classification and the renewal period. This approach correctly identifies that a hunting rifle, classified as a long firearm, Pika Chaliova, for civilian use, incurs a specific renewal fee. The Estonian Weapons Act Relvaluba and associated government regulations, Vabariigi Valitsus Määrust, stipulate fees based on firearm type and permit duration. For a hunting rifle, the renewal fee is Euros 20 for a 5-year permit. Therefore, calculating the total fee as Euros 20 is the correct and legally compliant method. Incorrect approaches analysis. One incorrect approach involves calculating the fee based on a handgun renewal rate. This is a regulatory failure because the Estonian Weapons Act clearly differentiates fees based on firearm type. Handguns have different classification and associated fees compared to long firearms like hunting rifles. Applying the handgun fee would be a direct violation of the stipulated fee structure. Another incorrect approach is to simply double the fee for a shorter duration, assuming a linear relationship for all firearm types. This is a mathematical and regulatory error. While some fees might be prorated, the specific regulations for weapon permit renewals in Estonia do not universally apply a simple doubling for half the duration across all firearm categories. The fee for a hunting rifle is a fixed amount for the 5-year period, not a per-year calculation that can be halved. A further incorrect approach is to apply the fee for a short firearm, Lühike Chaliov. This is a classification error and a direct contravention of the legal definition of a hunting rifle, which falls under the category of long firearms. Each category has distinct fee structures, and misclassification leads to incorrect fee assessment. Professional reasoning. Professionals must meticulously consult the relevant Estonian legislation, specifically the Weapons Act and its implementing regulations, to determine the precise fee structure for each type of firearm and permit duration. A systematic approach involving identifying the firearm category, confirming the permit renewal period, and applying the corresponding fee from the official schedule is essential. In cases of ambiguity, seeking clarification from the issuing authority is a critical step in ensuring compliance and avoiding errors. Question 11. What factors determine an applicant's eligibility for a weapon permit, Relvaluba in Estonia, particularly when the stated reason for possession is self-defense? Option A. A summary denial of the permit based on a general skepticism towards self-defense claims as a valid reason for weapon possession. Option B. The applicant's declaration of needing a weapon for self-defense, without further investigation into the specifics of their situation. Option C. The applicant's financial capacity to purchase and maintain a firearm, irrespective of their stated reason or personal suitability. Option D. A thorough assessment of the applicant's specific circumstances, including the nature of their self-defense concerns, their living environment, and a comprehensive background check to ensure they meet all legal requirements and pose no risk to public safety. The correct answer is D. A thorough assessment of the applicant's specific circumstances, including the nature of their self-defense concerns, their living environment, and a comprehensive background check to ensure they meet all legal requirements and pose no risk to public safety. Explanation. This scenario is professionally challenging because it requires balancing the applicant's stated need for a firearm with the stringent requirements of Estonian weapon permit law, specifically the need to demonstrate a genuine reason for possession and the absence of grounds for refusal. The applicant's vague initial statement about self-defense, without further elaboration, necessitates a thorough investigation by the authorities to ascertain if this reason is legitimate and not a pretext for an illegitimate purpose. The decision-maker must meticulously assess the applicant's circumstances against the legal criteria, ensuring public safety while upholding individual rights. The correct approach involves a comprehensive evaluation of the applicant's stated reason for needing a weapon permit, as stipulated by the Estonian Weapons Act, Relvaluba. This includes a detailed interview to understand the specific nature of the perceived threat, the applicant's living situation, and any prior incidents or credible concerns that justify the need for a firearm for self-defense. It also requires verifying the applicant's suitability through background checks, mental health assessments, and confirmation of their understanding of safe weapon handling and storage. This thoroughness ensures that the permit is granted only to individuals who meet all legal requirements and pose no undue risk to public safety, aligning with the Act's purpose of regulating weapon possession to prevent misuse. An incorrect approach would be to grant the permit based solely on the applicant's assertion of self-defense, without any further inquiry or verification. This fails to meet the legal obligation to establish a genuine and justifiable reason for possessing a firearm and bypasses crucial safety checks mandated by the Weapons Act. Ethically, it compromises public safety by potentially arming an individual without adequate scrutiny. Another incorrect approach would be to summarily deny the permit based on a generalized suspicion about self-defense claims without conducting a proper assessment of the applicant's specific circumstances. While the authorities must be vigilant, an arbitrary denial without due process or an opportunity for the applicant to substantiate their claim is contrary to fair administrative practice and the principles of justice. Finally, an incorrect approach would be to focus excessively on the applicant's perceived financial ability to purchase a weapon rather than the genuine need and suitability for possessing one. The Estonian Weapons Act prioritizes the applicant's legitimate purpose and personal suitability over their economic status when determining eligibility for a permit. Professionals should employ a structured decision-making process that begins with understanding the applicant's stated purpose. This should be followed by a systematic gathering of information to corroborate or refute the stated purpose, assessing the applicant's character and mental state, and ensuring compliance with all legal requirements for safe storage and handling. Any doubts or ambiguities should be thoroughly investigated before a decision is made. Question 12. The risk matrix shows a moderate likelihood of a firearm being misused due to insufficient storage security, coupled with a high potential impact if a weapon were to fall into unauthorized hands. An applicant for a Relvaluba weapon permit in Estonia proposes to store their firearm in a standard domestic safe that they claim is very strong, and that they will keep the ammunition separately. What is the most appropriate course of action for the issuing authority? Option A. Approve the permit based on the applicant's previous ownership of firearms, assuming their storage practices remain adequate. Option B. Focus on the applicant's stated reason for needing the firearm, e.g., sport shooting, and assume that a responsible individual will ensure adequate storage. Option C. Accept the applicant's verbal assurance that the safe is very strong and that ammunition will be stored separately, and proceed with the permit application. Option D. Request detailed specifications of the proposed safe, including its security class, anchoring method, and confirmation of separate ammunition storage, and document this information thoroughly before proceeding. Correct answer is D. Request detailed specifications of the proposed safe, including its security class, anchoring method, and confirmation of separate ammunition storage, and document this information thoroughly before proceeding. Explanation: the risk matrix shows a moderate likelihood of a firearm being misused due to insufficient storage security, coupled with a high potential impact if a weapon were to fall into unauthorized hands. This scenario is professionally challenging because it requires an applicant to demonstrate not only a genuine need for a firearm, but also a robust understanding and commitment to responsible ownership and secure storage, as mandated by Estonian law. The applicant's personal circumstances and proposed storage solutions must be rigorously assessed against the requirements of the Relvaluba Firearms Act and associated regulations. The best professional approach involves a thorough and documented assessment of the applicant's proposed firearm storage solution, directly referencing the specific requirements outlined in the Relvaluba. This includes verifying that the proposed safe meets the minimum security standards, e.g., resistance to unauthorized opening, anchoring requirements, and that the applicant has a clear plan for securing ammunition separately. The justification for this approach lies in its direct adherence to the legal framework, which places the onus on the applicant to prove they can meet the stringent safety and security obligations. This proactive verification ensures compliance and minimizes the risk of future incidents, aligning with the ethical duty to protect public safety. An incorrect approach would be to accept the applicant's verbal assurance of secure storage without independent verification or documentation. This fails to meet the legal requirement for demonstrating adequate security measures and relies on subjective trust rather than objective compliance. Ethically, it represents a dereliction of duty by not performing due diligence, potentially endangering the public. Another incorrect approach would be to focus solely on the applicant's stated reason for needing a firearm, such as sports shooting, without adequately scrutinizing the storage plan. While the reason for acquisition is important, it does not absolve the applicant or the issuing authority from the critical responsibility of ensuring secure storage as stipulated by law. This approach prioritizes one aspect of the application over another equally critical one, creating a significant regulatory gap. Finally, an incorrect approach would be to approve the permit based on the applicant's past ownership of firearms without re-evaluating their current storage arrangements. Laws and best practices evolve, and each application must be assessed on its current merits and proposed solutions, not on historical approvals. This overlooks the possibility of changed circumstances or a lack of adherence to current legal standards. Professionals should employ a systematic decision-making process that begins with a clear understanding of the legal requirements of the Relvaluba. This involves a detailed review of the application, including the proposed storage method, and cross-referencing it with specific legal provisions. Where ambiguity exists or assurances are made, independent verification and documentation are crucial. The decision should be based on objective evidence of compliance, prioritizing public safety and adherence to the law above all else. Question 13. The evaluation methodology shows that an applicant for a Relvaluba in Estonia has submitted a medical certificate stating they are in good general health, but lacks specific details regarding any history of mental health conditions. The applicant has also provided a certificate of completion for a basic firearms safety course. Considering the requirements of the Estonian Weapons Act, Relvaluba, what is the most appropriate course of action for the permit issuing authority? Option A. Request a more detailed medical report from the applicant's physician, specifically addressing any history of mental health conditions and their current stability, before proceeding with the application. Option B. Reject the application immediately due to the lack of specific information regarding mental health, as this is an automatic disqualifier. Option C. Issue the Relvaluba based on the provided certificates, assuming good general health encompasses mental well-being and that the safety course is sufficient. Option D. Accept the application as is and proceed to the next stage, planning to conduct a brief interview to gauge the applicant's mental state. The correct answer is A. Request a more detailed medical report from the applicant's physician, specifically addressing any history of mental health conditions and their current stability, before proceeding with the application. Explanation. The evaluation methodology shows that assessing an applicant's suitability for a weapon permit, Relvaluba, in Estonia requires a thorough understanding of the applicant's mental and physical capacity, as well as their adherence to safety regulations. This scenario is professionally challenging because it involves balancing an individual's right to possess a firearm for legitimate purposes against the paramount public safety interest. The decision-maker must critically evaluate potentially conflicting information and apply the provisions of the Estonian Weapons Act, Relvaluba, and associated regulations with utmost diligence. The correct approach involves a comprehensive review of all submitted documentation, including medical certificates and psychological assessments, to ensure they meet the stringent requirements outlined in the Relvaluba. This includes verifying that the applicant's health status, as certified by a qualified medical practitioner, does not present a risk to themselves or others, and that they have demonstrated the necessary knowledge of safe weapon handling and storage. This approach is correct because it directly adheres to the legal framework established by the Estonian government to regulate firearm ownership, prioritizing public safety through a systematic and evidence-based assessment process. An incorrect approach would be to grant the permit based solely on the applicant's stated intention for self-defense, without independently verifying the medical and psychological fitness assessments. This fails to meet the legal obligation to ensure the applicant is not a danger to themselves or others, as mandated by the Relvaluba. Another incorrect approach would be to overlook discrepancies in the submitted medical documentation, such as a lack of specific details regarding the applicant's mental health stability. This bypasses a critical safety check and violates the principle of due diligence required by the law. Finally, accepting a certificate from an unqualified individual or relying on hearsay evidence rather than official documentation constitutes a significant regulatory failure, as it undermines the integrity of the permit application process and compromises public safety. Professionals should employ a decision-making framework that begins with a thorough understanding of the Relvaluba and its implementing regulations. This framework should include a checklist of all required documentation and assessment criteria. When reviewing an application, professionals must critically analyze each piece of evidence, cross-reference information where necessary, and seek clarification or further assessment if any doubts arise regarding the applicant's suitability. The ultimate decision must be grounded in objective evidence and a clear application of the law, always prioritizing public safety. Question 14. The risk matrix shows a potential applicant for a Relvaluba in Estonia has a history of personal trauma and expresses significant fear for their safety, citing recent local incidents. They have submitted a detailed application outlining their perceived need for a firearm for self-defense and have provided a letter from a friend attesting to their responsible character. What is the most appropriate course of action for the issuing authority? Option A. Issue the Relvaluba immediately based on the applicant's expressed fear and the letter of recommendation, prioritizing their perceived need for self-defense. Option B. Deny the Relvaluba application solely due to the applicant's history of personal trauma, assuming it indicates a present unsuitability for firearm ownership. Option C. Conduct a comprehensive review of all submitted documentation, cross-reference information with relevant Estonian databases and authorities as permitted by law, and conduct a thorough interview with the applicant to assess their eligibility against the requirements of the Relvaluba. Option D. Grant the Relvaluba but impose strict, non-standard conditions on its use, without a full verification of the applicant's background and the validity of their stated need. The correct answer is C. Conduct a comprehensive review of all submitted documentation, cross-reference information with relevant Estonian databases and authorities as permitted by law, and conduct a thorough interview with the applicant to assess their eligibility against the requirements of the Relvaluba. Explanation. Scenario analysis. This scenario presents a professional challenge due to the inherent tension between an applicant's perceived need for a firearm for self-defense and the stringent requirements of Estonian weapon permit legislation. The applicant's emotional state and personal history, while understandable, must be evaluated against objective criteria defined by law. The challenge lies in balancing empathy with the duty to uphold public safety and the integrity of the weapon permit system. A thorough, objective assessment is paramount, avoiding subjective interpretations or undue influence from personal circumstances. Correct approach analysis. The best professional practice involves a meticulous review of all submitted documentation, cross-referencing information with relevant Estonian databases and authorities as permitted by law, and conducting a thorough interview with the applicant. This approach prioritizes adherence to the requirements of the Relvaluba Firearms Act and associated regulations. Specifically, it involves verifying the applicant's age, mental and physical fitness, absence of disqualifying criminal convictions or substance abuse issues, and demonstrating a valid reason for possessing a firearm that aligns with the Act's provisions. The focus is on objective evidence and legal compliance, ensuring that any permit issued meets the strict criteria set forth by Estonian law, thereby safeguarding public safety. Incorrect approaches analysis. One incorrect approach involves granting the permit based solely on the applicant's expressed fear and perceived need for self-defense, without independently verifying the grounds for this fear, or assessing the applicant's suitability according to the Relvaluba. This fails to meet the legal requirement for demonstrating a legitimate need and bypasses essential safety checks. Another incorrect approach is to deny the permit outright due to the applicant's past trauma without a thorough, objective assessment of their current mental and physical fitness as mandated by law. While past trauma is a factor to consider, it does not automatically disqualify an applicant if they can demonstrate current fitness and a legally permissible reason for a permit. A further incorrect approach is to rely heavily on the applicant's personal testimony regarding their firearm training and safe storage plans without seeking independent verification or assessing the adequacy of their proposed storage solutions against regulatory standards. This overlooks the need for concrete evidence of competence and compliance. Professional reasoning. Professionals in this field must adopt a structured decision-making process. This begins with a comprehensive understanding of the Relvaluba and its implementing regulations. The process should involve objective data collection, thorough verification of all applicant claims, and an impartial assessment of risk. Empathy is important, but it must not override legal obligations or compromise public safety. When faced with complex cases, professionals should consult with supervisors or legal counsel to ensure decisions are legally sound and ethically defensible. The ultimate goal is to make a decision that is consistent with the law and promotes the safety and security of the public. Question 15. The risk matrix shows a moderate likelihood of a firearm being misused due to inadequate storage, coupled with a high impact if such misuse occurs, leading to a significant overall risk rating for firearm ownership in Estonia. An applicant for a Relvaluba weapon permit in Estonia proposes to store their firearm in a standard household lockbox, which is not specifically designed for firearms and lacks robust security features. What is the most appropriate course of action for the issuing authority? Option A. Request detailed specifications and evidence of the proposed lockbox's security features and potentially require a more robust, legally compliant firearm safe to ensure adherence to the Estonian Weapons Act storage requirements. Option B. Accept the household lockbox as adequate storage, assuming it is locked, as the primary focus of the Relvaluba is on the applicant's suitability to own a weapon, not the specifics of storage. Option C. Prove the Relvaluba based on the applicant's assurance that the lockbox is sufficient for their needs, as the risk matrix indicates only a moderate likelihood of misuse. Option D. Deny the Relvaluba immediately due to the moderate risk identified in the matrix, without further investigation into the applicant's proposed storage. The correct answer is A. Request detailed specifications and evidence of the proposed lockbox's security features, and potentially require a more robust, legally compliant firearm safe to ensure adherence to the Estonian Weapons Act storage requirements. Explanation. The risk matrix shows a moderate likelihood of a firearm being misused due to inadequate storage, coupled with a high impact if such misuse occurs, leading to a significant overall risk rating for firearm ownership in Estonia. This scenario is professionally challenging because it requires balancing an individual's right to own a firearm for legitimate purposes against the paramount public safety concerns. The Estonian Weapons Act, Relvaluba, and associated regulations place a strong emphasis on responsible ownership, which includes secure storage. The challenge lies in assessing whether an applicant's proposed storage methods adequately mitigate the identified risks, especially when faced with potentially ambiguous or incomplete information. Careful judgment is required to avoid both unduly restricting lawful ownership and compromising public safety. The best professional approach involves a thorough and documented assessment of the applicant's proposed firearm storage solution, directly referencing the specific requirements outlined in the Estonian Weapons Act and its implementing regulations. This approach requires the applicant to provide detailed evidence of their storage arrangements, such as lockable safes meeting specific security standards, and to demonstrate an understanding of safe handling and storage practices. The responsible official must then verify this information, potentially through site visits or by requesting further documentation, to ensure compliance with legal mandates. This is correct because it directly addresses the identified risk by ensuring the applicant's storage plan meets the legally defined standards for preventing unauthorized access and misuse, thereby fulfilling the duty of care mandated by Estonian law. An incorrect approach would be to approve the permit based solely on the applicant's verbal assurance of secure storage, without requiring any tangible evidence or verification. This fails to meet the legal obligation to ensure adequate safety measures are in place, as stipulated by the Weapons Act, and ignores the risk matrix's indication of potential misuse. Another incorrect approach would be to deny the permit outright due to the moderate risk identified in the matrix, without giving the applicant a fair opportunity to demonstrate compliance with storage requirements. This would be an arbitrary decision, failing to consider the possibility of effective risk mitigation and potentially infringing on lawful ownership rights. Finally, accepting storage solutions that do not meet the minimum security standards prescribed by Estonian regulations, even if they appear good enough to the applicant, is also professionally unacceptable. This approach directly contravenes the legal framework designed to prevent firearm-related incidents and prioritizes convenience over mandated safety. Professionals in this field should employ a structured decision-making process that begins with a clear understanding of the relevant legal framework, Estonian Weapons Act and associated regulations. This should be followed by a comprehensive risk assessment, considering factors like the applicant's history, the type of firearm, and proposed storage methods. Crucially, the process must involve obtaining and verifying concrete evidence of compliance with all legal requirements, particularly regarding storage. If there are any doubts or ambiguities, further information should be requested from the applicant. The final decision must be clearly documented, with a rationale that explicitly links the decision to the legal requirements and the risk assessment. Question 16. The risk matrix shows a moderate likelihood of a firearm being misused due to insufficient storage security, coupled with a high potential impact if a weapon were to fall into unauthorized hands. Mr. Jonas, an applicant for a Relvaluba in Estonia, has a history of minor infractions and proposes to store his firearm in a standard household closet secured with a padlock. Considering the Estonian Weapons Act, Relvaluba, which of the following represents the most responsible and legally compliant course of action for the permit-issuing authority? Option A. Conduct a detailed inspection of Mr. Jonas's proposed storage location to verify compliance with the security standards mandated by the Estonian Weapons Act, and require specific upgrades if deficiencies are identified before issuing the permit. Option B. Deny the Relvaluba outright due to Mr. Jonas's past minor infractions, without a specific assessment of their relevance to firearm safety or his proposed storage. Option C. Issue the Relvaluba with a general recommendation for better security for the firearm, without specifying the required standards or the nature of the deficiencies. Option D. Issue the Relvaluba with a verbal warning to Mr. Jonas about the importance of responsible firearm storage, trusting his assurance that he will be careful. The correct answer is A. Conduct a detailed inspection of Mr. Jonas's proposed storage location to verify compliance with the security standards mandated by the Estonian Weapons Act, and require specific upgrades if deficiencies are identified before issuing the permit. Explanation. The risk matrix shows a moderate likelihood of a firearm being misused due to insufficient storage security, coupled with a high potential impact if a weapon were to fall into unauthorized hands. This scenario is professionally challenging because it requires balancing an individual's right to own a firearm for legitimate purposes against the paramount public safety imperative. The applicant, Mr. Jonas, has a history of minor infractions, which, while not directly related to firearms, raise questions about his overall adherence to regulations and responsible behavior. Careful judgment is required to assess whether his current circumstances and proposed storage methods adequately mitigate the identified risks, adhering strictly to the Estonian Weapons Act, Relvaluba. The best professional approach involves a thorough, documented assessment of Mr. Jonas's proposed firearm storage solution against the specific requirements of the Estonian Weapons Act. This includes verifying that the storage facility meets the minimum security standards outlined in the Act, such as being a locked safe or a purpose-built secure room, and that it is located in a place where unauthorized access is highly improbable. Furthermore, this approach necessitates confirming that Mr. Jonas has completed all mandatory training and possesses the necessary permits for the specific type of firearm he intends to possess. This aligns with the Act's emphasis on ensuring that only responsible individuals who can guarantee the safe storage and handling of weapons are granted permits, thereby fulfilling the state's obligation to protect public safety. An incorrect approach would be to grant the permit based solely on Mr. Jonas's assurance that he will be careful. This fails to meet the explicit requirements of the Weapons Act, which mandates demonstrable security measures rather than mere promises. It bypasses the due diligence expected of permit-issuing authorities and creates an unacceptable risk to public safety. Another incorrect approach would be to deny the permit solely because of Mr. Jonas's past minor infractions, without a specific assessment of their relevance to his current firearm ownership application or the proposed storage security. While past behavior can be a factor, the denial must be based on demonstrable grounds related to current fitness and adherence to the Weapons Act's provisions regarding safe storage and responsible ownership. Finally, an incorrect approach would be to approve the permit with a vague recommendation for better security, without specifying the exact deficiencies or referencing the legal standards. This lacks the clarity and enforceability required by the Weapons Act and leaves the security of the firearm to subjective interpretation, undermining the regulatory framework's intent. Professionals should employ a systematic decision-making process that begins with a comprehensive review of the applicant's history and proposed storage plan. This involves cross-referencing the proposed solution with the specific legal requirements of the Estonian Weapons Act, documenting all findings, and making a decision that is demonstrably justifiable under the law and prioritizes public safety. Any concerns should be clearly articulated and addressed through specific requirements or, if insurmountable, grounds for denial. Question 17. Benchmark analysis indicates that an applicant in Tallinn, Estonia, has applied for a weapon permit Relvaluba. The applicant, a small business owner, states they have recently experienced threats and feel increasingly unsafe, citing a specific incident involving vandalism at their premises. They express a strong desire for a firearm for personal protection. The firearms officer reviewing the application must determine the next steps. Which of the following represents the most appropriate course of action according to Estonian regulations? Option A. Advise the applicant that while their concerns are understood, the current legal framework does not prioritize personal feelings of insecurity for weapon permit issuance and suggest they explore alternative security measures. Option B. Conduct a thorough investigation into the applicant's background, verifying their age, mental and physical fitness, criminal record, and any grounds for suspicion of criminal activity, while also assessing the documented need for a weapon as per the Estonian Weapons Act. Option C. Recommend the applicant seek a permit for a less regulated item or explore private security options, as the process for a firearm permit is likely too stringent for their current situation. Option D. Issue the weapon permit immediately based on the applicant's credible fear of harm and the recent incident, as personal safety is a primary concern. The correct answer is B. Conduct a thorough investigation into the applicant's background, verifying their age, mental and physical fitness, criminal record, and any grounds for suspicion of criminal activity, while also assessing the documented need for a weapon as per the Estonian Weapons Act. Explanation. Scenario analysis. This scenario is professionally challenging because it involves a direct conflict between a citizen's perceived right to self-defense and the strict legal requirements for obtaining and possessing a firearm in Estonia. The applicant's personal circumstances, while potentially sympathetic, do not automatically override the established legal framework for weapon permits. A firearms officer must balance empathy with a rigorous adherence to the law. Ensuring public safety is paramount. Correct approach analysis. The best professional practice involves a thorough and objective assessment of the applicant's eligibility based strictly on the requirements outlined in the Estonian Weapons Act, Relvaluba. This includes verifying the applicant's age, mental and physical fitness, absence of criminal convictions or grounds for suspicion of criminal activity, and demonstrated need for a weapon. The officer must meticulously document all findings and ensure that all legal prerequisites are met before any recommendation or decision is made. This approach is correct because it upholds the rule of law, ensures consistent application of regulations, and prioritizes public safety by preventing unauthorized access to firearms. Incorrect approach is analysis. One incorrect approach would be to grant the permit based on the applicant's stated fear and perceived need for self-defense, without independently verifying all the statutory requirements. This fails to adhere to the Estonian Weapons Act, which mandates specific objective criteria for permit issuance, not subjective feelings of insecurity. Bypasses crucial checks that are in place to prevent firearms from falling into the wrong hands. Another incorrect approach would be to deny the permit solely based on the applicant's perceived emotional state or the officer's personal opinion about the applicant's character, without a formal, documented assessment of their eligibility against the legal criteria. This is arbitrary and discriminatory, as the law provides specific grounds for refusal, and personal bias is not one of them. A third incorrect approach would be to suggest the applicant obtain a weapon through unofficial or illegal channels, or to advise them on how to circumvent the legal process. This is a severe ethical and legal violation, undermining the integrity of the entire firearms licensing system and posing a direct threat to public safety. Professional reasoning. Professionals in this field must employ a systematic decision-making process. This involves 1. Clearly identifying the legal framework governing the situation, in this case, the Estonian Weapons Act. 2. Objectively gathering all necessary information and documentation from the applicant. 3. Independently verifying the applicant's eligibility against each specific legal requirement. 4. Documenting the entire process and all findings meticulously. 5. Making a decision based solely on the legal criteria and evidence, free from personal bias or external pressure. 6. Communicating the decision and its rationale clearly and professionally. Question 18. The assessment process reveals that an applicant for a Relvaluba in Estonia has a documented history of several minor public order infractions from their youth, none of which involved violence or weapons, and the most recent occurring over 5 years ago. The applicant has otherwise maintained a clean record and has provided evidence of responsible behavior and employment since then. Considering the Estonian Weapons Act, what is the most appropriate course of action for the authorities processing the Relvaluba application? Option A. Automatically deny the Relvaluba application due to the presence of any public order offenses, regardless of their minor nature or the time elapsed since they occurred. Option B. Request a new set of character references from individuals who have no knowledge of the applicant's past infractions, without independently verifying the applicant's history. Option C. Grant the Relvaluba application without further scrutiny, assuming that the applicant's current clean record is sufficient and the past minor offenses are irrelevant. Option D. Conduct a thorough, individualized assessment of the applicant's entire history, considering the nature, recency, and context of the offenses in relation to the overall assessment of their reliability and suitability to possess a firearm. The correct answer is D. Conduct a thorough, individualized assessment of the applicant's entire history, considering the nature, recency, and context of the offenses in relation to the overall assessment of their reliability and suitability to possess a firearm. Explanation. The assessment process reveals a scenario where an applicant for a Relvaluba weapon permit in Estonia has a history of minor, non-violent public order offenses. This situation is professionally challenging because it requires a nuanced interpretation of the Estonian Weapons Act, Relvaluba, and its associated regulations, specifically concerning the assessment of an applicant's reliability and suitability to possess a firearm. The core challenge lies in balancing the right to self-defense or sport shooting with the paramount public safety interest, as mandated by Estonian law. A careful judgment is required to determine if past minor transgressions pose a genuine risk to public safety, or if they fall within a scope that does not automatically disqualify an applicant. The best professional approach involves a thorough, individualized assessment of the applicant's entire history, focusing on the nature, recency, and context of any offenses. This approach prioritizes a comprehensive review of all submitted documentation and potentially seeking further clarification from the applicant or relevant authorities. The Estonian Weapons Act requires that an applicant be deemed reliable and not pose a danger to public order or safety. This means that, while past offenses are considered, a blanket disqualification based solely on the existence of minor offenses, without considering their severity, frequency, or the time elapsed since they occurred would be contrary to the spirit and letter of the law. The law emphasizes a holistic evaluation, allowing for discretion based on the overall profile of the applicant. An incorrect approach would be to automatically deny the permit based solely on the presence of any public order offense, regardless of its minor nature or how long ago it occurred. This fails to adhere to the principle of individualized assessment and the requirement to consider the overall reliability of the applicant. Such a rigid interpretation could lead to unfair denials and does not align with the law's intent to disqualify only those who demonstrably pose a risk. Another incorrect approach would be to overlook the offenses entirely and grant the permit without due consideration of the applicant's history. This would be a failure to uphold the public safety mandate of the Weapons Act, as it neglects a potentially relevant factor in assessing an applicant's suitability. The law explicitly requires consideration of factors that might indicate unreliability or a propensity to endanger others. A further incorrect approach would be to rely solely on the applicant's self-declaration of good character without independently verifying the information or considering the official records. While self-declaration is part of the process, the authorities have a duty to conduct due diligence and investigate any potential red flags that emerge from official records. The professional decision-making process for similar situations should involve a structured approach. First, thoroughly review all submitted documentation, including any criminal records or official reports. Second, assess the nature, severity, and recency of any disclosed offenses. Third, consider the context of these offenses and whether they indicate a pattern of behavior that would render the applicant unreliable or a danger. Fourth, if necessary, seek additional information from the applicant or relevant authorities. Finally, make a decision based on a comprehensive evaluation against the criteria set forth in the Estonian Weapons Act, ensuring that the decision is well-reasoned, documented, and justifiable under Estonian law. Question 19. Quality control measures reveal that an applicant for a Relvaluba weapon permit in Estonia has a documented history of seeking voluntary mental health treatment 5 years ago for stress-related issues, though they have no criminal convictions. The police are reviewing the application. Which of the following actions best reflects the appropriate procedure under Estonian law? Option A. Grant the Relvaluba automatically, as the applicant has no criminal convictions and the mental health treatment was voluntary. Option B. Issue the Relvaluba but attach a condition requiring the applicant to undergo mandatory psychiatric evaluations every 6 months. Option C. Conduct a thorough review of the applicant's mental health records, consult with a medical professional if necessary, and assess the current risk posed by the applicant to public safety, considering the voluntary nature of the past treatment and the absence of any subsequent incidents. Option D. Deny the Relvaluba immediately due to the applicant's history of mental health treatment, regardless of the circumstances or current risk. The correct answer is C. Conduct a thorough review of the applicant's mental health records, consult with a medical professional if necessary, and assess the current risk posed by the applicant to public safety, considering the voluntary nature of the past treatment and the absence of any subsequent incidents. Explanation. This scenario presents a professional challenge due to the sensitive nature of firearm ownership and the potential for misuse. The applicant's history, while not a direct disqualifier under the Estonian Weapons Act, Relvaluba, raises concerns about their suitability and the potential risk to public safety. Careful judgment is required to balance the applicant's rights with the state's responsibility to ensure public safety. The correct approach involves a thorough and objective assessment of all available information, including the applicant's mental health history and any reported incidents. This approach prioritizes the safety of the public and adheres to the spirit and letter of the Estonian Weapons Act, which mandates that permit may be denied if there are grounds to believe the applicant poses a risk to public safety or the safety of others. The Act requires the police to consider all relevant circumstances, and a history of erratic behavior, even if not leading to a criminal conviction, can be a valid ground for concern. This thorough review ensures that the decision is based on a comprehensive understanding of the applicant's potential risk. An incorrect approach would be to grant the permit solely based on the absence of a criminal conviction. This fails to acknowledge that the Estonian Weapons Act allows for denial based on grounds to believe the applicant poses a risk, which extends beyond criminal conviction to include factors like mental health stability and past behavioral issues. Such an approach neglects the proactive duty of the authorities to assess risk. Another incorrect approach would be to deny the permit immediately upon learning of the mental health treatment without further investigation. This constitutes a premature judgment and potential discrimination, as mental health treatment itself does not automatically disqualify an individual. The law requires an assessment of the risk posed, not a blanket denial based on a past condition. Finally, an incorrect approach would be to rely solely on the applicant's self-reporting without independent verification or consultation with relevant professionals. While self-reporting is a starting point, the authorities have a responsibility to conduct due diligence and gather all necessary information to make an informed decision, especially when public safety is at stake. Professionals in this field should employ a structured decision-making process that includes 1. Comprehensive information gathering from all available sources. 2. Objective risk assessment based on established criteria and legal frameworks. 3. Consultation with relevant experts, e.g., mental health professionals, when necessary. And 4. A clear, documented rationale for the final decision that aligns with legal requirements and ethical considerations. Question 20. The risk matrix shows a potential increase in the number of applications for certain types of firearms in Estonia. A firearms dealer is preparing a financial forecast for the upcoming quarter and needs to accurately estimate the total administrative fees associated with processing 15 new Relvaluba applications for standard hunting rifles. The base application fee for a Relvaluba is Euros 20, and there is an additional mandatory background check fee of Euros 5 per application. Furthermore, a Euros 2 administrative processing fee is applied to each application. What is the total estimated administrative cost for these 15 applications? Option A, Euros 375. Option B, Euros 300. Option C, Euros 320. Option D, Euros 405. The correct answer is D, Euros 405. Explanation: scenario analysis. This scenario presents a professional challenge in accurately calculating the potential financial impact of a firearm acquisition, specifically concerning the Estonian weapon permit Relvaluba application process. The challenge lies in correctly interpreting and applying the relevant fee structures and potential additional costs, ensuring compliance with Estonian legislation governing firearms and associated administrative processes. Miscalculation could lead to financial discrepancies, delays in the permit process, or even non-compliance with fee regulations. Correct approach analysis. The best professional approach involves a meticulous breakdown of all potential costs associated with obtaining a Relvaluba, as stipulated by Estonian law and administrative procedures. This includes the base application fee, any required background check fees, and potential fees for specific types of firearms or additional permits. The calculation must be precise, using the most current fee schedule published by the relevant Estonian authorities. This approach is correct because it directly adheres to the financial obligations mandated by the Estonian state for issuing weapon permits, ensuring transparency and preventing financial oversights. It reflects a commitment to regulatory compliance and responsible financial management within the legal framework. Incorrect approaches analysis. One incorrect approach would be to only consider the stated base application fee without accounting for potential supplementary charges. This fails to acknowledge the comprehensive fee structure that may apply depending on the specifics of the weapon permit application, such as the type of firearm or the need for specialized background checks. Another incorrect approach would be to estimate costs based on outdated information or general assumptions about permit fees in other jurisdictions. This is a critical failure, as it disregards the specific, legally binding fee schedule in Estonia, potentially leading to underpayment and subsequent administrative issues. A third incorrect approach would be to simply round up the base fee to the nearest convenient figure without performing a detailed calculation of all applicable charges. While seemingly cautious, this lacks the precision required for official applications and may still result in an inaccurate financial representation, potentially causing confusion or requiring resubmission. Professional reasoning. Professionals dealing with such applications should adopt a systematic approach. First, identify all potential cost components based on the specific circumstances of the permit application. Second, consult the official, up-to-date fee schedule provided by the Estonian Police and Border Guard Board, Politsei ja Piirivalveamet, or other relevant authorities. Third, perform a precise calculation, summing all applicable fees. Finally, document the calculation clearly, referencing the source of the fee information, to ensure accuracy and provide a transparent record for the applicant and the authorities.